The ACC files a brief in response to FSU's motion to dismiss.
The ACC lawsuit is always in the news, so we're back on the big mountain to break it down for you.
Hey, it's great to have you here again on the mountain. JY, Steve, and Steve, we just came out with a power ranking yesterday. We recorded it on Sunday. We had it drop on a Wednesday. And of course, new news comes out late Tuesday on the motion to dismiss from FSU in Mecklenburg County. And it answers, at least ACC's and ACC's mind, answers some of the questions we had and some of the top power ranked items from that episode.
You know, if both parties would just wait and watch the big mountain when it comes out each week, they'd be a little more prepared for their filings and stuff.
They just took their time a little bit more. I thought we'd be done with this for this week, but sure enough, here we go again. Record this sucker on a Wednesday evening so that we can get it out on a Thursday. So again, this is about as breaking as it gets for the big mountain right here. But was able to get through this motion. I know, Steve, you looked at it as well. They hit some big items. I mean, when we talk about that last episode we did, they get into the jurisdiction question. They get into the president's signature on the grant of rights question. They get into priority again. They get into all kinds of good stuff. I'll just start by saying everything we go over here that I'm going to be saying from this brief is from the ACC's point of view. Okay. So, you know, we're going to add our opinions and thoughts onto that as well. But when you see my head down reading, this is directly out of the brief that they filed. And I apologize, I got some gum in. I might sound a little funky. I really want to not try to cough on this episode like I'm having some issues with. So I apologize for the gum, but let's dig into this sucker. On February 27th, again, the ACC filed a brief in opposition to the FSU motion to dismiss or stay the lawsuit in Mecklenburg County, North Carolina. In their summary of argument, the ACC states that the two key items here. Number one, Florida is a priority jurisdiction in which the first served lawsuit takes priority. To avoid this application of Florida's priority law, they took a shotgun approach. FSU took a shotgun approach, claiming everything from jurisdiction issues to a claim they never really signed the grant of rights. So they kind of hit all kinds of different items. Again, the ACC uses this shotgun approach to try and pierce that to some degree. The second item, they talk about FSU's other arguments for dismissal only raise questions of fact, and they show no reason, much less substantial injustice, that would require the North Carolina court to defer to Florida. So they get into 6 arguments here. Some of them are fantastic. Some of them are, I'm going to be pretty brief on. The first 3 here, we're going to dive into a little bit deeper than we will the last 3. So the first one here is, there was and is a controversy. There was and is a controversy. FSU claimed that the ACC filed their lawsuit before there was any controversy. The ACC had bargained for a covenant not to sue in the grant of rights and was entitled to enforce that covenant when a breach was imminent, according to the ACC. The ACC states that the Declaratory Judgment Act allows for and permits a determination of a controversy before obligations are repudiated or rights are violated. They then go into a history lesson on the public nature and the comments that FSU Board of Trustees made. You know, everybody knew what was going on in kind of the second half of 2023. I'm not going to go through that. They put some of that detail into the filing. I'm not going to waste our time here with that. But much later in the document, when they get to the stay motion, which I'm going to get to at the very end, but I'm moving this up here because it goes to this controversy piece. They write, or they state in their brief, that this controversy has been ongoing since August 2023, if not before, when FSU began planning to breach the grant of rights. They did so through individual briefings of trustees to avoid sunshine laws. They actually had that in their original filing as well, but they're bringing that back up again here. When the board convened a meeting the day before the Christmas holiday for an emergency matter, it did so to try and be first to file a lawsuit. They now can't grieve that a race to the courthouse ensued just because they lost the race. Again, according to the ACC. I found that kind of funny that they're like, hey, you're saying there was this race to the courthouse, but it was only a race to the courthouse because you lost the race to the courthouse. Taking a little bit of jab there. It doesn't really hold any legal water, taking a jab, but I just found that part funny. Had to throw it in here. So, that's it for the controversy. Let's go to number 2. This is that 2/3 vote by the ACC board, and whether or not they took a vote at all and got 2/3 majority in order to file this complaint. FSU says this was unauthorized by the ACC board. I'm going to go over some of their items here. I got to be honest, I found this a little bit weak in terms of what they say here. But at the same time, I'm not really sure it necessarily matters a whole lot. I know it wasn't our power ranking argument, so I want to talk about what they say here. But when we get to number 3 after this, it's the best one of the whole deal. So let's talk about this 2/3 vote of the ACC board that was required by the bylaws to file this complaint. First, they state the ACC does not need to allege compliance with its internal bylaws or governance procedures in order to bring a complaint. That's always been in the back of my mind. I haven't said that on any previous episode, but and I don't know how much water that holds in the court of law and with a judge, but I've oft wondered, does it even really matter to a judge if they followed their own internal governance structure? I don't know the answer. The ACC says that's not enough for us to not file a complaint. That's their opinion on it. The second thing they say, the ACC is entitled to interpret its bylaws concerning its own internal affairs. Again, this is internal, has nothing to do, judge, with you, quite frankly. Number 3, the bylaws require approval of the initiation of a material litigation. They note that material in the bylaws is not defined. Just bringing up gray, as much gray matter as you possibly can. Number 4, the board already approved the ESPN agreements which authorized the ACC to take all reasonable actions to protect the agreement. So they say no vote was even required because the authority for this was already given to them in the agreement. I find that interesting. A little bit talking in circles, maybe. I want to get your opinion on that, Steve. Let me do 2 more, and then I'm going to throw it to you. Number 5 here, the ACC membership approved the amended complaint on January 12th, 2024, and this included the original complaint. So this is new. This is something that I know we haven't talked about, and I haven't seen covered anywhere. But they do say that the membership approved by at least this 2/3 majority the amended complaint on January 12th, 2024. The last thing they say, and something that you brought up on the power ranking episode, allowing retroactive ratification is allowed as an affirmance of a prior act. So I say it's weak just because I didn't like the way they laid this out. To me, the heavy hitters were at the end. And I've heard from several lawyers who are like, you want to come out with a bang. You want to hit whatever your number 1 item is, you want to hit them with that first. And I almost feel like they did the opposite. They started with what I would consider the weakest, and I think they got to the strongest here when you're talking this, retroactive, if that's allowed, retroactive, that, they did approve this. Not only was it retroactive, but they approved the amended complaint. And so I don't know. It just, I guess it depends on how you're trying to lay out your argument there. That's why they did it this way. What are your thoughts?
First of all, I'm going to guess that they ended with that because I honestly think that they just didn't feel like they were in jeopardy, that they were in very much risk.
That it was even needed.
That it was even needed,
yeah.
But they're going to throw it in there just to address it.
Okay.
We've said all along, neither one of us has really thought that the question of the 2/3 vote that was really important. It was something we said, hey, they could just it was easily remedied. Most likely, they could go back and retroactively vote to approve it if that was even necessary. But we weren't even sure if a judge would really even care, like they suggest. So that none of that surprised me. It kind of goes along the lines of the thinking that we already had. That just it's not a huge question now. So some of the other questions are really big. And I think it's kind of important to look at, there's 2 parts of this, and I think the ACC is saying, whoa, wait a minute, slow down. you have the merits of the case, the statements of fact,
correct,
about the contract and how it was performed and all of those things. And I think the ACC is saying, let's get to that later when we have a trial or when we get, at this point, it's just a matter of they want the North Carolina judge specifically to focus on, should this case be held here? Do we have priority? Yep. Which is what we talked about.
Number 1 and 2.
Number 1 and
venue
number 2.
And jurisdiction.
Venue and
that's
jurisdiction.
What it's about. Yep.
And that's what they want this North Carolina judge, Mecklenburg County judge, to focus on, for sure. Which makes a lot of sense because, like we talked about, it will be a huge win if they can get this case held first, go first in North Carolina. So I want to talk about a couple of those other things. Yep. Controversy. Obviously, there was already a controversy, and to me, that's a it's not that it's a non-issue, but it's obvious.
Yes.
The Florida State Board of Trustees, the different individual members, were telegraphing this all along.
Yep.
We've had a couple commenters and viewers. They took exception to how I laid out the timeline with when they voted on it, when they said, and when it was filed. So I'm not going to go exactly into the timeline, other than to say it was pretty obvious to everybody that what was coming when the meeting was was held, why they were holding the meeting, and what the outcome of that meeting was going to be to file suit. So obviously there was a controversy, and I'm curious as to, they say going back all the way to August of 23.
That's what they say.
Right, and so I'm wondering there if they actually have evidence that that's when they started going back and considering, or if it lines up with that timeline where Florida State is asking for retroactively back to August of 23.
Oh, interesting, yeah.
So I'm really curious on that, if that was a coincidence or not. One other thing, and as far as the race, I mean, it's important because it's going to go into venue and jurisdiction, but at the same time it's silly. It's kind of a silly thing you were too slow, haha, you're too slow. I mean, it feels like elementary school playground tactics.
For sure.
The judge is going to have to make a determination on this. I think Florida State could easily argue, yeah, we did lose the race because we actually went through our process of going to the board, having a meeting, having this approved, and they are also still making that argument that the ACC didn't do their process that they should have. Right. And again, we don't feel that holds much water, but it's going to be up to the judge. I don't know how the judge is going to go on this. Yeah. But yes, they won the race, but that argument seemed a little juvenile to me.
There was several pieces in this that seemed juvenile to me. I'm not going to bring them all up, but they like to piss on each other when they can. And I'll get into another topic here a little bit later. Yeah. It's like, can we just get to the facts?
Right.
Like, stop with the piss and match. But that's what they do. I think they get jollies out of that. So let's get to me, the biggest one, the third item here. The North Carolina court has jurisdiction over FSU, according to ACC. Not according to me, according to the ACC. So let's walk through this here. They're saying they do have jurisdiction. This was a very long, probably the longest section of it. I'm going to try to keep this as high level and hit the important parts. I'm not going to hit everything. Again, it was pretty beefy. They talk about that Maryland actually made this very similar argument back in 2013 about this jurisdiction type of issue. They start out by listing two cases. One case that went to the Supreme Court and another case that was Troy University versus an NC resident. I'm not going to get into those, but they basically say by using these two cases, they state that FSU can sue or be sued in North Carolina law because they subjected themselves to the Nonprofit Corporation Act and due to the fact that they conducted a commercial activity, thus waiving their sovereign immunity. The ACC then goes on to say this is actually bolstered by Florida law, and this is when it gets really good for me. Florida law states that FSU can sue and be sued under Florida Statute 1001.72. We've mentioned that before in some of our other episodes here. FSU, their answer to this, and they did this in one of their responses, one of their briefs or filings, their answer to this was that this means only in the state of Florida. Okay, we can only be sued or be sued in the state of Florida. That's it. The ACC claims that if Florida wanted to limit it to just the state of Florida, they would have simply put the words in there, in this state or in the state of Florida. They didn't do that. This was actually done in other statutes in Florida law, but it's not here. To me, and when we read that from FSU's side, and they're saying, oh, they really mean in all cases, or they really mean in all cases in Florida. They would have said that. I'm with ACC on this, and I think this holds a lot of water. Lastly, the ACC states, sorry, my gum. Okay. Lastly, the ACC states that FSU waived this defense because of the opposition to the motion to seal in North Carolina by requesting adjudicatory powers of the North Carolina court. They made a general appearance before the North Carolina court and then now have submitted themselves to that jurisdiction. So this is really interesting. Again, a judge is going to have to come down on this, a judge in North Carolina, whether or not they have jurisdiction over that. But I think the ACC raises several really interesting points here, specifically this claim that Florida meant to say just the state of Florida. That's not what it says. And if they wanted it to say that, it would have said that. Do you have anything there, Steve, before I go to the last three items?
Yeah, again, we're back to the whole idea of jurisdiction.
Yep.
That's going to be huge in this initial part of the case. This is the first major battle, venue and jurisdiction.
Yep.
First major battle of this war. So first of all, I'll say, both sides are filing cases and counter claims in both states. I'm pretty sure that if I remember correctly, the ACC has counterfiled in the suit going on in Florida.
Yep.
So I mean, I think both sides could say you could make the same argument either way for
Absolutely.
that.
Yep.
And at the end of the day, it's going to come down to a judge. First of all, North Carolina, and so here's the thing: you may read that and have one interpretation. I may read it and have another interpretation.
Right.
Another lawyer. When we were doing the PAC, we talked about, I work with lawyers every day, helping us to interpret law. And a lawyer once told me, one of our government lawyers told me, you could put 8 lawyers in a room and give them the same case, the same facts, whatever, and you will get 8 different opinions on what it means and what it should be. So a judge is going to have to make a determination on that. And he, again, if the ACC can get that ruling saying that the venue should be there, they should go first, that North Carolina has jurisdiction, that would be a major, massive victory for them. But I think there is that chance, when you're asking a judge in North Carolina to interpret state of Florida laws,
right,
what was intended, I think that's a little rough. I think it's a tough ask. We'll see if he's willing to do it, but it also gives him that opportunity to punt. We talked about this before. Asking a North Carolina judge to interpret state of Florida law just gives him that opportunity to say, you know what, I don't want to make a ruling on this. This is a public facility, public institution of the state of Florida. We're talking about state of Florida laws. Let's kick it to that court, let them determine it before we take up the case later. So I don't know if the judge will do that or not. Nobody knows it.
Right.
But I think that there is that definite opportunity for that. So it's high risk, high reward here. It's a major victory. So going back to the PAC case, you mentioned we never even got to the arguments of the case.
Right.
Because why? Well, first of all was the TRO, and then the preliminary injunction, and then, okay, let's ask the Washington State Supreme Court to rule. And so once they lost that TRO, once they lost the preliminary injunction, these are all procedural matters.
Yes.
And then the Washington Supreme Court decided not even to get involved.
Right.
They knew at that point, because they lost those procedural matters, before they could even really get to the merits of the case, the nitty gritty, they were screwed.
Right.
And so at that point they were willing to settle. So this opening battle, we may have the same situation. It'll be interesting to see how the North Carolina judge rules.
And just because a North Carolina judge potentially rules that venue is correct and there is jurisdiction, and they're going to hear the case, that doesn't mean the Florida case gets thrown out. Like, that's not what it means. I think there's a little bit of like confusion. Like, it's got to be one or the other. No, it could easily be both.
Right.
We don't know that yet, and right now they're trying to figure out, is it going to be both at the same time? Who's going to go first? I mean, that's how early we are in this whole process. So.
And I agree with you on that, but I do think if North Carolina if the ACC is able to get North Carolina to move forward first, even if we're talking 2 weeks earlier, 6 weeks earlier, or just a total pause on the Florida case until I still think that's a massive win for the ACC. That would put them in a big position for negotiating. Hey, case is in our venue. It's going first. We can make our case, our argument where we want to. And I think that just gives them a leg up, not necessarily on the entirety of the case from beginning to end, but to the point where, hey, FSU, we got you over a barrel. Let's go to the negotiating table, and we're going to ask for a much bigger number than maybe you thought you were going to have to pay.
Well, there's a lot of rumors floating around that they're getting close to a settlement around the 200 mark.
Yeah.
I don't know where it's coming from. I don't put a lot of stock into that yet. I just feel like we're so early on. Neither side has a leg up yet.
Yep.
And so, I didn't want to get into that, but as you're saying that, I don't think we're close to a settlement here. I mean, I think there's too many unanswered questions to have one party think that they're in the commanding lead, like happened in the PAC situation. Yes. I don't see that happening until some of these answers get figured out.
Right, and we kept seeing those. We had the same rumors in the PAC case leading up to, and okay, there's rumors of a settlement, but no action really went forward until there was a couple rulings, and one side lost a couple rulings, and then that got the juices flowing to settle. So. And that could happen here if one side or the other scores some big wins early. And conversely, I said it would be a huge win for the ACC if they get absolute massive win for Florida State. If they get this out of North Carolina and back into the state of Florida, massive win. I think that would be a near knockout blow. The pressure would be on the ACC at that point to negotiate, come up with a way, come up with a number, because the perception at least would be the risk of, if they don't figure this out and settle, there's a risk of the ACC not even existing anymore. So this is just a huge jurisdiction and venue, massive.
And if we were there now, that we're like, hey, it's going to be heard first, in Florida, I would even not knowing who said it, I'd put a lot of more weight on a $200 million settlement because of that.
You're right.
But I don't think we're close to that. So let's get to the next item. The one we called a dud. It is the claim by FSU that they did not actually execute the grant of rights because it was signed by the president. So this is a basis for dismissal. And, I'm a little disappointed. Again, they should have listened to our daggone episode on this, but they hit around one of the items. The first thing they say is the president's signature stated that they had the right, power, and capacity to execute the agreement. I've stated that several times, and that's great that that's on there, and I think that does hold water. They get into then saying they raise the fact that they receive many years of benefits for this contract or from this agreement, and then they raise questions as to waiver and estoppel. So I would start by saying, hey, we raised the performance issue, right? They've had many years of performance under this. They didn't use the word performance, but that's what they're getting at. They then go into waiver and estoppel. I would have liked to have them say something. I think the first piece is about apparent authority. They're using the contract language for that, but clearly a president has apparent authority there. They didn't really get into that. So to us, I don't want to waste any more time on that. We knew that was kind of a dud. I kind of agree with what they say here. Let's move on. I don't want to talk about that anymore. Number 5, the ACC's claim of breach of confidentiality, breach of fiduciary duty, and breach of duty of good faith and fair dealing are valid. There is no North Carolina law that supports this as a claim for dismissal. FSU cites no case law in support of this argument. They then go over and over these multiple times, but in the terms of a dismissal, they're completely unfounded. It's more back to what you said a little bit ago. These are facts of the case, not facts for dismissal, right? So let's, and you said a little while back, ACC's kind of, I don't say they're putting the brakes on it, but they're like, hold on, timeout. We're getting, at least for the motion to dismiss, we're getting ahead of ourselves.
Yeah.
That's clearly what this one is. They're getting ahead of themselves. They're just asking for a dismissal here. These are facts of the case.
Right.
Then the last thing they have here, FSU has failed to prove that litigating this matter in North Carolina would be a substantial injustice, something that I talked about in the very beginning. And this gets back to the motion to stay the case. That's really what FSU is using here for this. The ACC claims that neither the procedural fencing argument, as has already went over earlier, nor the statutory factors under the NCGS apply here, are true or are to be applied here. FSU largely ignores the burden to prove a substantial injustice, and they may have not met that burden in order to stay the case in North Carolina. They go on and on and on about this for quite a while, basically just saying they didn't meet this burden in order to stay, so it's kind of a non-issue for the ACC. Again, I'm talking about the ACC, and I kind of would agree with them on that. So, I think items 1, 2, 3, and maybe 4 really are answers to potential issues that FSU brought for a motion to dismiss or stay. I actually think the responses are pretty just. I think they hold a lot of water here. That doesn't mean a judge is going to not, deem it to be dismissed or stayed. I think a dismissal is, as we said in the very beginning, extremely unlikely. I think a stay is very unlikely as well. The question is going to be the venue case. I know we keep repeating ourselves, but I just don't think this thing gets dismissed. I don't see it.
Yeah, that kind of leads to my overall thoughts on the case in general and this filing. I think that the ACC has some advantages on the procedural matters. Mm-hmm. They were the first to file. They also, Florida State obviously telegraphed what they were doing, what was going on and all that. So they definitely have some advantages on the procedural side. Mm-hmm. And I think they know that, and that's why in a lot of these filings, like the ACC is pointing out, they're putting a lot of the ACC's case is really strong in these matters of fact. They're a lot stronger. A lot of the major allegations that basically have to be, we need depositions, mm-hmm. we need items entered into evidence as far as emails, communications, all those things. So they are a little bit, I think they're just trying to show, hey, we have so much evidence here that the ACC acted in bad faith, that this thing shouldn't even be heard or whatever. And I think that's a little bit of a Hail Mary. Mm-hmm. And again, I think the ACC has some advantages as far as the procedural. Now, in the one area, so I agree with you on the dismissal. I cannot see a path to a dismissal here. Yeah. The stay, I am probably 50-50 on that. Okay. Because I think there's a couple things here where judges hate being overruled, or they hate being turned over on appeal. Yeah. They hate when they make a decision and then someone takes it to federal court, kind of going over them, whatever. Yeah. They don't like that to happen. They like their rulings to stand and not be questioned. And I just think there's because a lot of these things are dealing with Florida law. I just think there's some opportunities where a judge might say, you know what, we need a Florida judge to rule on these. I'm going to stay this until a Florida judge can rule and let this play out. So to me, I think the matter of a stay is probably about 50-50.
Okay. All right. Yeah, could be. We will find out soon enough. Yeah. The reason we have so much to talk about is because we do have these filings in 2 different states. Yes. So there's 2 motions to dismiss. There's 2 briefs on both of those. There have been 2 lawsuits in 2 different. That's why this seems to be never ending. I'm sure we're going to get answers to the motion to dismiss down in Florida here probably next week, or heck, it might happen tomorrow. Right. So that's why it's just there's so much going on. It's 2 different jurisdiction or 2 different courts that are at play here.
And I would be shocked at either state this was dismissed. I don't think we see anything in either court that really shows that a dismissal is warranted.
Agree. I think a dismissal in both courts is almost a slam dunk that it isn't going to happen. And everything that we said here, I just want to remind everybody, this is about the motion to dismiss. This is not about the merits of the case. we both think, if you go back and look at our power rankings, we actually have a more power on the FSU side with some of this. It doesn't mean they're going to win, but we think their arguments are a little bit stronger here. This is just about the dismissal of this case. That's all we talked about in this. So, don't give us hate mail saying, FSU's so much stronger. We would agree. I think their arguments are stronger, but for now. But this is just the motion to dismiss. So, hey, with that, we thank you guys for watching. We appreciate our commenters. I know we had a couple people saying right after our last one, hey, there's another one out. We appreciate that. We get on it as soon as we can. Sure enough, we were recording here on a Wednesday night, so we got to do this pretty quickly. Make sure you give us a like on this video. Make sure you remember to subscribe to our channel. And with that, we'll see you guys next time on The Big Mountain.
Who gets to go first? The $1 million question.